Before we begin, a quick disclaimer. The information provided in this presentation is for educational and informational purposes only and is not intended as legal or professional career advice. The path to becoming an attorney is unique for every individual. You should always consult with academic advisors, law school admissions counselors, and qualified legal professionals for advice tailored to your specific situation and goals. Think back to 2010. The Deepwater Horizon oil rig explodes in the Gulf of Mexico. 11 men lose their lives. For 87 straight days, a geyser of crude oil gushes from the seafloor, poisoning an entire ecosystem. We all saw the images on the news. The fire, the oil-slicked water, the desperate attempts to cap the well. But behind the headlines, a different kind of battle was just beginning. It wasn't fought with containment booms or dispersant chemicals. It was fought in boardrooms and courtrooms. It was a war of legal briefs, expert testimonies, and multi-billion-dollar lawsuits. This war was fought by environmental lawyers. They were the ones who had to prove not just that BP was negligent, but they had to quantify the damage. How do you put a price on a dead dolphin? How do you calculate the economic devastation to a fishing community that has lost its livelihood for a generation? How do you read a complex geological survey to argue that the company ignored warning signs buried deep beneath the earth? The lawyers who won those battles, who secured billions of dollars for restoration and compensation, weren't just good at arguing. They were scientific detectives, economic strategists, and masters of a legal framework so complex it makes tax law look like a children's book. Now maybe that's why you're here. You feel that pull. You see a problem in the world, whether it's toxic waste in a local river, a battle over land rights, or the global threat of climate change, and you want to be on the front lines fighting. But the path feels incredibly unclear. What do you actually study to become one of these people? Do you load up on political science and history? Or do you spend 4 years in a lab coat majoring in biology or chemistry? Make the wrong choice in your undergraduate years, and you could be walking into law school at a massive disadvantage, potentially wasting years of your life and tens of thousands of dollars on a degree that doesn't actually prepare you for the realities of this field. That confusion ends today. This video is the definitive roadmap. We are going to cut through all the noise, all the bad advice from well-meaning college counselors, and give you the step-by-step strategic guide to what you need to study to become a top-tier environmental lawyer in the United States. We're not just going to list majors. We are going to build your entire educational foundation from the ground up, showing you how each subject you choose translates directly into a powerful weapon in your future legal arsenal. By the end of this presentation, you will have a crystal-clear plan of action. You will know exactly what classes to take, what skills to prioritize, and how to position yourself as the kind of candidate that top law schools and elite environmental law firms are desperately searching for. So let's get started. The first and most pervasive myth we need to shatter is that you must major in environmental science or environmental studies. Now, can you become an environmental lawyer with one of these degrees? Absolutely. But is it the best and most strategic path? For many, the answer is a surprising no. Here's why. These programs are often interdisciplinary, meaning they give you a little bit of everything, a little biology, a little policy, a little sociology, a little chemistry. It's a great overview, a survey of the landscape. But in the high-stakes world of environmental law, you don't win by knowing a little about everything. You win by having deep, undeniable expertise. You win by being the person in the room who understands the science better than the opposition's expert witness. This brings us to the first pillar of your education, the scientific bedrock. You must, without question, become fluent in the language of science. Environmental law is an abstract legal theory. It is grounded in the physical, chemical, and biological realities of our world. When a corporation is accused of violating the Clean Air Act, the case will hinge on atmospheric chemistry and particulate matter measurements. When you're litigating a Superfund site cleanup under CERCLA, the entire battle is about hydrogeology, soil toxicology, and chemical engineering. You cannot effectively cross-examine a PhD chemist on their analysis of groundwater contamination if you don't fundamentally understand concepts like molecular weight, solubility, and transport pathways. You're just an actor reading lines. To be a true warrior, you need to understand the science as well as, or better than, they do. So, what does this mean for your undergraduate major? It means you should seriously consider majoring in one of the hard sciences. Let's break down the most powerful options. First, chemistry. A chemistry degree is arguably one of the most potent foundations you can build. Virtually every major environmental contamination case revolves around chemicals. Think about it. Lead in the water in Flint, Michigan, PFAS, the forever chemicals, contaminating military bases and drinking water supplies across the country, pesticides running off from farms into rivers. As a chemistry major, you'll learn analytical chemistry, which is the science of identifying and quantifying substances. This is the exact skill set used to prove a pollutant is present and that it came from a specific source. You'll study organic chemistry, which gives you the framework to understand the structure and reactivity of toxic industrial compounds. When a company's expert witness presents a report full of gas chromatography and mass spectrometry data, you won't just stare at the charts blankly. You'll know how to pick them apart, to question the methodology, to find the fatal flaw in their argument. You'll be a lie detector for bad science, and in a courtroom that is a superpower. Second, let's talk about biology, specifically with a focus on ecology or toxicology. The Endangered Species Act is one of the most powerful environmental laws on the books. Litigation under this act doesn't happen in a vacuum. It requires a deep understanding of population dynamics, habitat requirements, and ecosystem stability. If you're fighting to stop a development that threatens a critical habitat, you need to be able to dissect an ecological impact statement and argue why the developer's mitigation plan is scientifically inadequate. Toxicology, a subfield of biology, is equally crucial. It's the study of the adverse effects of chemical substances on living organisms. This is the science that connects a pollutant to the harm it causes, whether it's linking a specific carcinogen from a factory to a cancer cluster in a nearby town, or proving that a certain pesticide is responsible for a fish kill downstream. A strong biology background allows you to tell the most important story in any environmental case. The story of cause and effect, of a poison and its victim. The third powerhouse science major is geology or hydrogeology. So much of environmental law is about what happens beneath our feet. Where does the water go? Where does the pollution go? If a gas station's underground storage tank leaks, a hydrogeologist is the one who can map the plume of contamination as it moves through the groundwater toward a town's drinking water wells. If a mining company wants to build a new facility, geologists are the ones who assess the risk of acid mine drainage and land instability. Cases involving land use, mining regulations, and water rights are built on a geologic foundation. Having this expertise allows you to understand the very ground on which the legal battle is being fought, giving you a three-dimensional view of the problem that other lawyers simply cannot see. Choosing one of these hard science majors, chemistry, biology, or geology, does something incredibly important. It gives you a rigorous, quantitative, and empirical framework for thinking. It trains you to base arguments on data, to follow logical chains of evidence, and to identify weaknesses in flawed reasoning. This is the exact same mental discipline required to be a phenomenal lawyer. You're not just learning facts about the environment. You're learning a way of thinking that is directly transferable to legal analysis. It signals to law schools and future employers that you are a serious, analytical thinker who isn't afraid to get their hands dirty with technical data. You're not just another applicant who wants to save the planet. You're someone who has already invested years in understanding the fundamental scientific principles that govern it. This immediately sets you apart from the thousands of other applicants coming from more traditional pre-law tracks. It makes you a rare and valuable asset before you've even read your first legal case. This scientific bedrock is your foundation, the concrete slab upon which your entire legal career will be built. Without it, everything else is unstable. So you have your scientific bedrock. You can read a toxicology report, you can understand the half-life of a chemical, you can trace a pollutant's journey through a watershed. But here's the brutal truth that separates the hopeful idealists from the effective advocates. In the world of law, policy, and power, scientific facts alone almost never win the day. Why? Because the decisions that poison rivers or save forests are not made in a laboratory. They are made in boardrooms, in hearing rooms, and on spreadsheets. And in those rooms, they speak a different language. It's the language of money. This is your second pillar. A deep, ruthless understanding of economics. Forget what you think you know about economics from a dry theoretical class. For an environmental lawyer, economics is not about supply and demand curves. It's about forensics. It's about dissecting an opponent's argument and exposing the lies hidden within their numbers. When a massive corporation wants to build a new chemical plant on the edge of a low-income community, they won't come to the town hall meeting and say, "We want to expose your children to carcinogens for profit." No, they will come armed with an army of consultants and a mountain of charts, all showing one thing: jobs, economic growth, progress. They will paint a beautiful picture of prosperity, and they will use the language of economics to do it. If you can't speak that language, you've already lost. You can stand up and talk about the beauty of the local wetlands, the sanctity of clean air, the moral injustice of it all, and they will nod politely, call you a passionate idealist, and then the town council will approve the permit, because you didn't fight them on their battlefield. To win, you have to become a warrior of finance. You need to be the one who can stand up after their slick presentation and say, "Thank you for that. Now let's talk about the real numbers. Let's talk about the externalities you conveniently left off your balance sheet." Externalities. That's the magic word. It's the economic term for all the costs that a company dumps onto society. The $10 million cost of dredging the river after their toxic runoff kills all the fish. The $20 million increase in community healthcare costs over the next decade from respiratory illnesses. The $5 million drop in property values for every homeowner within a 2-mile radius. You need to learn how to quantify this. You need to study environmental economics and learn the techniques for placing a dollar value on things that corporations pretend are worthless. A pristine view, a day of fishing, a child's ability to breathe without an inhaler. When you can do that, you transform the debate. You are no longer the tree hugger fighting against progress. You are the fiscally responsible one, the protector of the community's long-term economic health, exposing their plan for what it is. A scheme to privatize profits while socializing their costs onto the backs of taxpayers and families. Majoring or minoring in economics, or at the very least taking every environmental economics course you can find, is non-negotiable. It is the language of your enemy. You must speak it more fluently than they do. Once you understand the science and the money, you need to understand the machine. The machine that turns ideas and protests and scientific reports into actual enforceable rules. This is the third pillar. Political science and government. The law is not some sacred text handed down from on high. It is a messy, complicated, and deeply human product of political compromise, backroom deals, and brutal power struggles. To ignore this is like a soldier trying to win a war by only reading the rules of engagement, without ever studying the terrain or the nature of the enemy. Studying political science teaches you how the machine is built. You learn about the separation of powers, sure, but you also learn the crucial difference between a statute passed by Congress and a regulation issued by the Environmental Protection Agency. You learn about the Administrative Procedure Act, a piece of legislation that sounds incredibly boring, but is, in fact, the primary battlefield for almost all modern environmental law. It governs how agencies like the EPA create rules, and it's where a lawyer can challenge a new regulation that weakens clean air standards, or sue an agency for failing to enforce the law. Think about it. A corporation wants to get a permit to dump more pollution into a river. The fight doesn't start in a courtroom. It starts in the quiet, bureaucratic hallways of a state environmental agency. There's a public comment period. There are hearings. There are economic impact statements. An environmental lawyer who understands the political and administrative process can intervene at every single one of these stages. They can rally public support, submit expert testimony, and build a mountain of evidence showing that the agency is legally required to deny the permit. They can weaponize the bureaucracy against itself. By the time the corporation even thinks about going to court, the smart lawyer has already built an impenetrable fortress of administrative procedure around the river. Most of the biggest environmental victories are won not with a dramatic courtroom speech, but with a meticulously crafted, 200-page comment letter citing obscure sections of agency regulations. That is power. And it comes from studying government, but it goes deeper. You need to understand the political motivations. Why did that senator from a farming state suddenly add a rider to a bill that guts protections for a certain pesticide? Follow the money. Look at their campaign contributions. Political science teaches you to see the invisible strings that control the puppets of power. It shows you that the Clean Water Act isn't just a law. It's a living document, constantly under attack by lobbyists and special interests, and you need to understand their tactics to effectively defend it. You need to know how the federal budget process works, because if you can't fund the EPA, it doesn't matter what the law says, there will be no one to enforce it. This knowledge turns you from a simple lawyer into a strategist, capable of seeing the entire chessboard, not just the single square in front of you. So now you have the 3 core pillars of knowledge: the scientific reality, the economic argument, and the political machinery. But there's one final ethereal layer that ties it all together. It's the why. Why does any of this matter? What is the moral foundation for protecting a species from extinction? What are our obligations to future generations we will never meet? This is the realm of philosophy and ethics. It might sound abstract, but it is the source code for your entire career. It is your why. Studying philosophy, specifically environmental ethics, forces you to grapple with the foundational questions. Is a forest valuable only because it provides timber and oxygen for humans, or does it have a right to exist for its own sake? This isn't just a late-night dorm room debate. It is the central question behind some of the most cutting-edge legal theories today, like the rights of nature movement, which argues that ecosystems themselves should have legal standing to sue in court. Lawyers are winning these cases from Ecuador to Ohio. They are succeeding because they can articulate a philosophical argument that persuades a judge to see the world in a new way. Philosophy teaches you logic. It teaches you how to construct a sound argument from the ground up, and just as importantly, how to deconstruct and demolish a flawed one. It is the ultimate training in critical thinking. When a corporate lawyer argues that private property rights should allow their client to do whatever they want with their land, a philosopher lawyer is ready. They can counter with arguments from John Locke about not wasting resources, or from the public trust doctrine, the ancient legal and philosophical idea that some resources like water and air are the common property of all people, held in trust by the government for our benefit. You can't learn that in a chemistry class. This moral and logical clarity is what will sustain you through the long, difficult cases. It's what transforms a job into a calling. It's the difference between being a legal technician and a true advocate for the planet. Because knowing all of this, the science, the economics, the politics, is useless if you can't forge it into a weapon of persuasion. And that weapon is built from words. Think about it. The courtroom, the negotiation table, the public hearing, these aren't laboratories. They are theaters of persuasion. The data from your hydrology report, the figures from your economic impact study, they are meaningless until you breathe life into them. Until you weave them into a story that a judge, a jury, or a town council can understand, believe, and act upon. This is where so many aspiring environmental advocates fail. They become masters of the what, but they neglect the how. They have the facts, but they don't have the narrative. And in the battle for hearts and minds, which is what every legal case truly is, the better story always wins. So, how do you learn to tell the better story? You go back to the source. You study the very disciplines designed to understand the human condition, to deconstruct arguments, and to build new ones. You need to immerse yourself in the humanities. And I know what some of you are thinking. Humanities? I'm trying to save the planet, not analyze Shakespeare. But you are profoundly mistaken. This isn't about being well-rounded. This is about being dangerous. It's about being more formidable than the army of corporate lawyers you will one day face. Those lawyers, I promise you, have mastered the art of rhetoric. They can take a mountain of evidence showing their client poisoned a river and twist it into a story about economic prosperity, personal responsibility, and burdensome government regulation. They are expert storytellers. And if you can't fight them on that field, you've already lost. Your training begins with English and literature. Every great work of fiction is a case study in human motivation, conflict, and consequence. When you read a novel, you're not just following a plot. You're learning how to build a world, how to create a compelling character, and how to structure a narrative that carries emotional weight. Your client, the small town fighting the new landfill, the indigenous community whose sacred land is threatened by a pipeline, they are the protagonists of your story. The corporation, the negligent government agency, they are the antagonists. The legal complaint you file isn't just a document, it's the opening chapter. The discovery process is the rising action. The trial is the climax. The verdict is the resolution. Understanding these narrative principles allows you to frame your case in a way that resonates on a primal human level. You learn to choose your words with the precision of a poet, because the difference between calling it industrial runoff and toxic sludge seeping into a children's playground is the difference between a dismissed case and a multi-million-dollar verdict. Next, you must conquer philosophy. This is the operating system for your brain. Law at its core is applied philosophy. When you study logic, you're not just playing with abstract puzzles. You're learning to identify the flawed reasoning, the logical fallacies, that opposing counsel will use to mislead a jury. They'll use an ad hominem attack to discredit your expert witness. They'll create a straw man argument to misrepresent your position. They'll present a false dichotomy, suggesting the only choice is between jobs and a clean environment. Philosophy gives you the tools to spot these traps, dismantle them in real time, and expose them for the cheap tricks they are. But it goes deeper. You need to study ethics. What is justice? What do we owe to future generations? Does a corporation have a moral responsibility beyond its duty to its shareholders? These are the questions at the heart of environmental law. When you're arguing about the precautionary principle, the idea that we should act to prevent harm even with incomplete scientific certainty, you are engaging in a profound ethical debate. Your opponent will argue for a high burden of proof. You have to argue from a place of moral foresight. You have to be able to articulate why protecting the potential for life is more important than protecting a quarterly profit margin. That is not a legal argument. It is a philosophical one, and the lawyer who can make it more convincingly will win. Then you must become a student of history. Every environmental law on the books, the Clean Air Act, the Clean Water Act, the Endangered Species Act, is a scar. It's a monument to a past catastrophe. These laws weren't written in a vacuum. They were forged in fire, literally. To understand the Clean Water Act, you need to understand the history of the Cuyahoga River in Ohio, a river so polluted with industrial waste that it caught fire more than a dozen times. A lawyer who just knows the statute sees a set of rules. A lawyer who knows the history sees the public outrage, the political courage, and the national reckoning that led to its creation. That context is power. It allows you to stand before a judge and say, "Your Honor, the legislative intent of this law was precisely to prevent what is happening here again. We cannot go back to a time when our rivers burned." History gives your legal arguments a soul. It connects your specific case to the long, ongoing struggle for a healthier world. It transforms you from a simple practitioner of the law into a guardian of its purpose. Finally, you must take all this raw material, the narrative skill from literature, the logical rigor from philosophy, the contextual weight from history, and you must forge it in the fire of public speaking and debate. This is non-negotiable. Join the debate team. Do mock trial. Get into a moot court program. Do whatever it takes to get on your feet and argue. This is the laboratory where theory becomes practice. It's where you learn to think under pressure, to organize a complex argument in seconds, and to command a room with nothing but your voice and your reasoning. You will feel the adrenaline of facing a sharp opponent who is actively trying to tear your case apart. You will learn how to parry their attacks, how to find the weakness in their position, and how to deliver a closing statement that leaves no doubt. The corporate lawyers you'll face have spent years in this fire. They are comfortable, they are confident, and they are ruthless. They will not be intimidated by your scientific data. They will not be moved by your passion. They will only be defeated by a superior argument, delivered by a more skilled advocate. The skills you build in debate are the skills you will use for the rest of your life. Whether you're arguing a motion in front of a skeptical judge, cross-examining a hostile CEO on the witness stand, or trying to persuade a community to fight back, your ability to speak with clarity, confidence, and conviction will be your single greatest asset. So, while your pre-med friends are memorizing organic chemistry pathways, you'll be deconstructing the rhetoric of Abraham Lincoln. While future engineers are learning fluid dynamics, you'll be grappling with the ethical dilemmas of Kant. It might feel like you're on a different path, a softer path. You are not. You are building the intellectual and rhetorical engine that will power your entire legal career. You are learning how to wield the one weapon that can truly change the world. So you've built the engine of your mind with science and economics, and you've crafted the weapon of persuasion with the humanities. Now, how do you package it all? How do you choose the one label, the one undergraduate major, that signals to law schools that you are the real deal? That you're not just another applicant, but a future force to be reckoned with? That's where things get complicated. Let's start by dismantling the biggest, most pervasive, and most dangerous piece of advice you will ever hear about getting into law school. Your undergraduate major doesn't matter. On one level, this is technically true. Law schools don't have required prerequisite majors like medical schools do. There's no rule that says you must study political science or history. A student with a 4.0 GPA in art history and a 178 on the LSAT is going to get into Harvard Law. No questions asked. The numbers GPA and LSAT are the undisputed king and queen of the law school admissions world. So yes, in that very narrow technical sense, your major doesn't matter. But in every other sense, in every way that actually matters for building a career with purpose, that advice is a trap. It's a siren song for the intellectually lazy. It encourages you to pick the easiest possible major to inflate your GPA, treating your 4 years of undergraduate education as nothing more than a stepping stone you have to get across as painlessly as possible. Following that advice is the single biggest strategic mistake you can make. Your major isn't just a box to check. It is the single most powerful tool you have to build the foundation for your entire legal career. before you even set foot in a law school. It's your opening argument. It's the headline of your story. It's the first and loudest signal you send to an admissions committee that you're not just smart, you're serious. So, if we throw out the old broken advice, what do we replace it with? We replace it with a framework, a strategic blueprint for choosing a major, or for building out your current major, to make you the most compelling environmental law candidate imaginable. This framework rests on 3 foundational pillars. Your goal isn't to find a major with a perfect name. It's to build an undergraduate education that is strong in all 3 of these areas. Pillar number 1, rigorous analytical training. This is the bedrock of all legal education. Law is, at its core, the art and science of argument. It's about taking a massive, messy set of facts, statutes, and precedents, and distilling it down into a clear, logical, and persuasive narrative. It's about reading dense, complex texts and identifying the core issue. It's about thinking 10 steps ahead of your opponent. You need a major that forges your brain into an analytical weapon. This is where the classic pre-law majors actually get it right. Philosophy is phenomenal for this. Teaches you pure, unadulterated logic. You learn to deconstruct arguments, identify fallacies, and build your own logical proofs from the ground up. History is another giant. A history major learns how to sift through mountains of conflicting evidence, weigh the credibility of sources, and construct a compelling narrative that explains why things happen the way they did. That is the exact skill set a litigator uses every single day. Political science is obvious, teaching you the structure of the very governmental and regulatory systems you'll be working within. And don't sleep on economics. Economics is the language of modern policy. Understanding concepts like externalities, cost-benefit analysis, and market-based solutions like carbon pricing isn't just helpful. It's essential for understanding why environmental regulations are structured the way they are. Any of these majors will sharpen your mind to a razor's edge, and that will show in your LSAT score and your ability to succeed in law school. But here's the problem. If you only focus on Pillar 1, you become a brilliant legal mind with absolutely nothing to talk about. You're a master swordsman with no sword. This brings us to Pillar number 2, substantive scientific literacy. This is the environmental in environmental lawyer. This is what separates the generic, well-meaning applicant from the candidate who is ready to do the work on day 1. You cannot be an effective advocate for the environment if you do not speak the language of science. Period. End of story. Imagine you're in court, cross-examining an expert hydrologist hired by a massive chemical company. They're using terms like parts per billion, non-point source pollution, and potentiometric surface. If you don't understand what those terms mean, you are not just at a disadvantage, you are committing malpractice. You will be unable to poke holes in their testimony. You will be unable to effectively communicate the science to the judge and jury. You will lose. You need to be able to read a toxicological report, understand the basics of an ecological impact statement, and grasp the fundamental science behind climate change. This is non-negotiable. This is where the hard sciences and specialized environmental programs shine. Majors like environmental science, biology, chemistry, geology, or ecology provide this foundation. They teach you the scientific method, data analysis, and the complex interconnected systems that govern the natural world. A geology major understands groundwater flow in a way a political science major simply doesn't. A chemistry major understands the fate and transport of pollutants in a way a history major never will. Having this scientific literacy doesn't just make you a better lawyer down the road. It makes your application scream authenticity. It shows the admissions committee that your interest in environmental law isn't just a vague philosophical preference. It's a deep, substantive commitment grounded in a real understanding of the issues. This leads us directly to the third, and perhaps most important pillar, a compelling narrative and genuine passion. Law school admissions officers are human beings. They read thousands of applications. After a while, the numbers start to blur. What they remember is the story. Your major is the title of that story. And for your story to be believable, it has to be authentic. You have to actually care. First, on a practical level, you will get a better GPA in a subject you are genuinely fascinated by. You'll go the extra mile on papers, you'll participate in class, you'll actually enjoy the learning process. But more importantly, your major should align with your stated goals. It creates a coherent narrative that makes sense. When an admissions officer sees an application from an environmental studies major who wants to be an environmental lawyer, the story writes itself. It shows a long-term focused commitment. It's a straight line. If they see an application from a finance major who suddenly claims in their personal statement that they want to save the planet, it raises questions. It's a jagged, less believable path. It's not impossible, but you're starting from a deficit of credibility. Your major is your chance to show, not just tell them who you are and what you care about. So the billion-dollar question: what majors live in the sweet spot? What fields of study allow you to build all three pillars at once? The absolute top-tier choices are the interdisciplinary ones. An environmental studies or environmental science major is often the gold standard. These programs are explicitly designed to be interdisciplinary. You'll take the hard science classes fulfilling Pillar 2. You'll also take classes in environmental policy, economics, and ethics, which builds the analytical rigor of Pillar 1. And of course, it perfectly establishes the narrative of Pillar 3. It's a direct, unambiguous signal of your intent. Another powerhouse option is public policy with a concentration in environmental policy. This major is all about Pillar 1. It's the study of how governments solve problems, but it allows you to aim that analytical firepower directly at the environmental substance of Pillar 2, creating the perfect story for Pillar 3. Similarly, a major in economics with a focus on environmental and resource economics is an incredibly sophisticated choice. It gives you the hardcore quantitative and analytical skills that law schools adore, while teaching you the economic drivers of pollution and conservation. This shows a level of understanding that is miles ahead of the average applicant. And don't overlook majors like geology or earth systems science. These hard science degrees give you an unparalleled depth of knowledge in issues related to land, water, and resources, the very things at the heart of many environmental legal battles. Now, what if you're already a junior, and you're a history or English major? Is it too late? Absolutely not. Remember, it's not about the label of the major, it's about the three pillars. If your major has Pillar 1 locked down, your mission is to strategically use the rest of your academic career to build the other two. Use your electives to take classes in ecology, environmental chemistry, or conservation biology. Add a minor in environmental science. Write your senior thesis on the history of the Clean Air Act or the literary representations of the wilderness. Your task is to deliberately build the bridges between your core analytical training and your passion for the environment. You have to consciously construct the story that a more specialized major tells automatically. Ultimately, your choice of what to study is the first major decision on your path to becoming an environmental lawyer. It's your chance to build the intellectual architecture you'll rely on for the rest of your career. It's about forging the analytical mind of a lawyer, acquiring the substantive knowledge of a scientist, and telling the compelling story of an advocate. But the major is just the blueprint. The real structure is built course by course, class by class. What are the specific, must-take classes that will transform your application and prepare you for the realities of law school? What are the hidden gem courses, the ones that pre-law advisors never tell you about, that will give you an almost unfair advantage? That's where we're going next. Alright, let's peel back the curtain. The first category of courses that will give you this advantage are what I call the foundational fortifiers. These aren't the sexy, headline-grabbing classes. In fact, they're the ones most pre-law students, even the smart ones, actively avoid. And that is precisely why they are your golden ticket. First on this list, accounting. Yes, accounting. I can feel you recoiling through the screen. You're thinking, I want to save the planet, not become a CPA. But you have to understand a fundamental truth of environmental law. You will spend a massive amount of your time fighting, negotiating with, and suing corporations. And what is the native language of a corporation? It's not English. It's the language of money. It's the language of balance sheets, income statements, and financial projections. Accounting is the Rosetta Stone that lets you speak their language fluently. Imagine this scenario. A massive industrial plant is polluting a river. Your organization sues them to force the installation of a new, multi-million-dollar filtration system. The company's high-priced lawyers stand up in court and say, Your Honor, we'd love to comply, but the cost of this system would be catastrophic. It would bankrupt us. We'd have to lay off 1,000 local workers. It's a powerful, emotionally charged argument. The judge is listening. The local media is listening. Now, the average lawyer, the one who took political science and philosophy, might argue about the moral imperative to protect the river. But you took accounting. You've spent the weekend poring over their public financial filings. You stand up and say, Your Honor, with all due respect, that's fascinating. Because according to their own 10-K filing with the Securities and Exchange Commission, The company spent twice the cost of this filtration system on stock buybacks last quarter alone. They list a capital improvement budget that could cover this installation 3 times over without even touching their operating cash flow. Their argument isn't one of financial impossibility, it's one of financial priority. In that moment, you don't just win the argument, you detonate their entire defense. You've shown the judge that you are not just passionate, you are prepared. You speak their language and you can expose their lies on their own turf. That is power. Taking a course in basic corporate finance alongside accounting doubles this superpower. The second foundational fortifier is statistics. If accounting is the language of business, statistics is the language of science. And environmental law is a battlefield of dueling scientific claims. A company will hire a team of experts to produce a 100-page report filled with charts and graphs, concluding that their chemical runoff has a statistically insignificant impact on local wildlife. It looks intimidating. It looks official, but to someone trained in statistics, it might be a house of cards. You'll be the one who can look at their methodology and say, wait a minute, your sample size is too small to draw a meaningful conclusion. You've cherry-picked the data from these specific years while ignoring the more damning data from the previous decade. Your p-value is 0.06, which you're calling insignificant, but you failed to disclose the massive confidence interval that suggests the real impact could be dramatically higher. You're not just arguing with their conclusion, you're dismantling the very foundation of their evidence. You're showing the court that their science is actually sophisticated marketing. In law school and in your career, you will be inundated with data. The ability to critically analyze it, to understand its limitations, and to use it to build your own bulletproof arguments is not a soft skill. It is a core competency of a modern environmental lawyer. Don't just take the basic intro class. If you can, take a class on data analysis or statistical modeling. You're not trying to become a statistician. You're trying to become a lawyer who can't be fooled by one. Now let's move to the second category, the contextual connectors. These are courses that build the intellectual scaffolding around the law, helping you understand the real-world systems where your legal battles will take place. And the most underrated course in this entire category is urban and regional planning. Most people think environmental law is about saving forests and whales, and it is. But it's also about zoning variances, land use permits, transportation infrastructure, and the placement of waste facilities in low-income neighborhoods. It's about the very design of our cities and suburbs. A course in urban planning teaches you the vocabulary and the mechanics of how our built environment gets made. You'll learn about environmental impact statements, or an EIS, from the perspective of the people who actually write and review them. So when you're a lawyer challenging a new highway extension, you won't just be looking at the legal text of the National Environmental Policy Act. You'll understand the traffic flow models they used, the flaws in their population growth projections, and the politics behind their zoning decisions. It gives you a practical, ground-level understanding that most lawyers simply don't have. They see the law as an abstract text. You see it as a tool that shapes the physical world block by block. And to supercharge that knowledge, you take the second contextual connector, Geographic Information Systems, or GIS. If you take only one practical technical skill-based course in your entire undergraduate career, make it this one. GIS is, simply put, the science of spatial data. It's how you make smart maps that tell a powerful story. With GIS, you can map the spread of a pollution plume from a factory and overlay it with demographic data to show that it's disproportionately affecting minority communities. You can map the loss of critical habitat for an endangered species over time, creating a devastatingly clear visual for a judge or jury. It's one thing to say in a legal brief, the defendant's actions have fragmented the forest. It is another thing entirely to show a map where a vibrant, contiguous green space is slowly and brutally chopped into isolated, dying islands over a period of 10 years. In a world drowning in information, the ability to present a clear, compelling, data-driven visual story is a form of magic. Putting proficient in ArcGIS on your resume for a law firm or an environmental nonprofit makes you an exponentially more attractive candidate. They won't have to hire a technical consultant for every case. They'll have you. You're not just another pre-law student. You're a strategic asset from day one. Finally, we have the third category, the human accelerators. These are the courses that sharpen your ability to communicate, persuade, and understand the most complex variable in any legal equation: people. The first is almost a cliché, but its importance cannot be overstated. Public speaking, or, even better, competitive debate. Many students think, I'll learn how to argue in law school. That is a catastrophic misconception. Law school is not a beginner's course in public speaking. It's the Olympics. You are expected to show up ready to compete. The Socratic method, where professors cold call students and grill them on complex legal cases in front of 100 of their peers, is designed to test your ability to think and speak under extreme pressure. A student who has spent a year or two in a debate club has already been through that fire. They know how to structure an argument on the fly, how to anticipate counter-arguments, and how to project confidence even when they're uncertain. They know the difference between rhetoric and logic, and when to use each one. This isn't about being the loudest person in the room. It's about being the most effective. It is a skill that will serve you every single day of your career, from a courtroom to a community meeting to a negotiation with opposing counsel. The final hidden gem, the one that ties everything together, is a course in social psychology or sociology. Why? Because every environmental issue is a human issue. The Clean Air Act is not just a statute. It's a massive, complex attempt to change the behavior of millions of people and thousands of companies. Why do some communities embrace renewable energy while others fight it tooth and nail? Why is it so hard to get people to change their consumption habits, even when they know the stakes? These aren't legal questions. They're psychological and sociological ones. These courses teach you about cognitive biases, group dynamics, risk perception, and the science of persuasion. You learn why simply presenting people with facts is often the least effective way to change their minds. This knowledge is pure gold for an environmental lawyer. It will help you craft public comment campaigns that resonate. It will help you mediate disputes between angry stakeholders. It will help you understand the jury in the box, the judge on the bench, and the CEO across the negotiation table. It allows you to see the invisible currents of human behavior that truly shape the outcomes of environmental conflicts. Taking these courses, accounting, statistics, urban planning, GIS, public speaking, and psychology, does more than just pad your transcript. It fundamentally changes you as a candidate and a future lawyer. It shows an admissions committee that you are a serious, strategic thinker who has gone beyond the obvious. It gives you a multidisciplinary toolkit that will allow you to not just survive, but thrive in law school. And it lays the groundwork for you to become a truly formidable environmental advocate, one who can fight on any front, be it a courtroom, a spreadsheet, a map, or the hearts and minds of a community. But a brilliant transcript is only one piece of the puzzle. How do you translate these academic skills into real-world experience before you even apply to law school? What are the internships, volunteer opportunities, and projects that will make your application impossible to ignore? That's the next critical piece we need to build. Let's talk about building your story, because that's what this is. Your law school application isn't a spreadsheet of your grades and test scores. It's a narrative. It's the answer to the most important, unwritten question on the form. Why you? Why should they bet on you? Why should they believe that you, out of thousands of brilliant applicants, are the one who will actually go out and protect the planet? Your GPA says you're smart. Your real-world experience proves you're serious. Think of it like a legal case. Your grades are the evidence that you have the intellectual capacity, but your experiences, your internships, your volunteer work, your projects, that's your closing argument. That's the emotional, compelling proof that you have the passion, the drive, and the grit to see this through. An admissions officer at a top law school isn't just admitting a student. They're investing in a future colleague, a future world changer. You need to show them they're making a safe bet. So where do you start? Let's talk about the golden ticket. Internships. This is where you get your first taste of the real work. It's where you transform from a student who is interested in environmental law to an apprentice who is involved in it. And there are levels to this game. At the very top, you have the federal heavy hitters, the Environmental Protection Agency, the EPA. Getting an internship here as an undergrad is like getting a backstage pass to the biggest show in town. You'll be inside the very organization that writes and enforces the nation's most critical environmental regulations. You might spend a summer helping to research the impact of a new chemical for the Toxic Substances Control Act, or compiling data for an enforcement action under the Clean Air Act. It's not just a line on a resume. It's a paradigm shift in your understanding of how the system works. You'll see the messy, complicated political reality of environmental protection from the inside. And you'll be able to write about that experience with a sophistication that most applicants simply can't match. Then there's the Department of Justice, specifically the Environment and Natural Resources Division, or ENRD. This is the nation's environmental law firm. They are the lawyers who sue polluters on behalf of the United States. They defend federal agencies when they're sued by industry. An internship here is the holy grail. It is incredibly competitive, but if you can get it, you are signaling to every law school in the country that you are operating at the highest level. You're seeing the litigation side, the courtroom battles that define the boundaries of environmental law. And of course, there are the legendary nonprofits. The Natural Resources Defense Council, the Sierra Club, Earth Justice. These are the Davids fighting the Goliaths. Interning at one of these organizations demonstrates your commitment to the advocacy side. It shows you're driven by a mission. You might be doing policy research for a new campaign to protect old-growth forests, or helping lawyers prepare comments on a proposed pipeline project. You'll learn that environmental law isn't just about what happens in a courtroom. It's about public pressure, media campaigns, and building coalitions. Proves you have fire in your belly. But let's be realistic. These national-level internships are incredibly competitive. They're the Ivy League of pre-law experience. So what if you don't get one? Does that mean your dream is over? Absolutely not. In fact, some of the most powerful experiences happen closer to home. Look at your state-level environmental agency. In California, it's the California Air Resources Board, a global leader in climate policy. In Texas, it's the Commission on Environmental Quality. Every single state has an agency like this, and they are on the front lines. This is where the rubber meets the road. Federal laws set a floor, but states do a massive amount of the implementation and enforcement. Working at a state agency shows you understand that environmental issues are local. You might be helping to process permits for a new development, investigating a local pollution complaint, or working on new state-level recycling regulations. It's tangible. You can point to a river in your state and say, "I worked with the team that's trying to clean this up." That's a powerful story. Even more accessible, and in some ways more impactful, are the local and regional nonprofits. The small, scrappy organizations. The Hudson Riverkeeper Alliance, a local chapter of the Audubon Society, a community group fighting for environmental justice in a low-income neighborhood. Don't underestimate the power of this experience. At a huge national organization, you might be a small cog in a giant machine. At a local land trust, you might be the only intern. You'll be given real responsibility. You could be tasked with researching the ownership history of a parcel of land they want to conserve. You might be asked to draft outreach materials for a community meeting. You'll see firsthand how a small, dedicated group of people can make a monumental difference in their own backyard. This shows initiative, a willingness to do the unglamorous work, and a genuine connection to a place. Law schools love this. It's authentic. Now let's move beyond internships to the heart of your application. Consistent, meaningful volunteer work. I'm not talking about a one-off beach cleanup day you did for 3 hours. I'm talking about a sustained commitment. Admissions committees can spot resume padding from a mile away. They want to see that your passion for the environment is a part of who you are, not just something you did for a summer. Think about citizen science projects. Many local conservation groups need volunteers to help monitor water quality in streams, conduct bird counts, or track invasive species. This is brilliant for 2 reasons. First, it shows a commitment to the scientific underpinnings of environmental law. You're not just talking about clean water, you're out there collecting the data that proves whether it's clean or not. Second, it demonstrates long-term dedication. You can't monitor a stream just once. It requires showing up month after month, in good weather and bad. Or what about community organizing? Find a local group that's fighting a specific environmental threat, a proposed landfill, a factory that's violating its air permits, the clear-cutting of a local forest. Volunteer for them. You'll be doing pre-lawyering without even realizing it. You'll be helping to inform the public, persuade local officials, and build a case for action. You'll learn that law is a tool, but community power is the force that wields it. This is an incredible story to tell in an application essay. Finally, let's talk about the intellectual heavyweight division, independent projects and research. This is where you prove you have the academic horsepower and the intellectual curiosity to thrive in law school. The most direct path is through undergraduate research with a professor. Find a professor in the political science, environmental studies, economics, or even history department who is working on something that interests you. Ask if you can help. You could spend a semester helping a professor analyze the legal challenges to the Endangered Species Act, or researching the history of water rights in the American West. This experience culminates in the holy grail of undergraduate academic work, the senior thesis. If your university offers it, you must write a thesis on an environmental topic. This is your chance to become a legitimate expert on one specific thing. It's a year-long project where you will read hundreds of articles and books, analyze complex information, and construct a 100-page airtight argument. This is the single best preparation for law school you can possibly get. It teaches you how to think, research, and write like a lawyer. And when you can put on your application that you wrote a thesis titled Property Rights and Rising Tides, a legal analysis of coastal adaptation strategies, you are sending a clear signal. You're not just a student, you're a scholar. And for the boldest among you, there's one final power move. Start something yourself. Don't wait for an opportunity to be handed to you. Create one. Found an environmental club on campus. Start a podcast where you interview local environmental leaders. Organize a campaign to get your university to divest from fossil fuels or to reduce its plastic waste. This is the ultimate demonstration of leadership, passion, and initiative. It shows that you don't just identify problems, you actively work to solve them. That's the very definition of a great lawyer. Do you see how the pieces fit together? Imagine an applicant. She spent a summer interning for her state's Department of Environmental Protection, where she learned about water quality permitting. Back at school, she volunteered for a local riverkeeper group, pulling water samples every month. Then, for her senior thesis, she wrote a deep analysis of the Clean Water Act's failures to control agricultural runoff. That's not a list of activities. That is a story. It's a powerful, coherent narrative that screams, I am passionate about clean water, and I have attacked this problem from the government, advocacy, and academic angles. I know what I'm talking about, and I'm ready for the next step. That is an application that is impossible to ignore. Every experience you have builds on the last, creating a portrait of a person who was born to do this work. You've built the academic foundation. You've now forged it in the fire of real-world experience. You have your story, but now comes the great gatekeeper, the standardized, intimidating, and non-negotiable hurdle that stands between you and law school, the LSAT. How do you prepare for this notoriously difficult exam? And how do you craft a score that makes your dream school a reality? Taming that beast is our next battle. The LSAT isn't just a test. It's a crucible. It's designed to do one thing with ruthless efficiency. Measure your ability to think like a lawyer. It doesn't care about your GPA, your volunteer hours, or your passion for saving the planet. It doesn't test what you know. It tests how you think. It's a raw, unfiltered assessment of your skills in logic, reasoning, and comprehension under intense pressure. And for that reason, it's one of the most significant factors in law school admissions. A high score can open doors to top-tier environmental law programs and unlock life-changing scholarships. A low score can slam those same doors shut. So, how do we conquer it? First, you must understand your enemy. The LSAT is broken down into 3 scored sections, plus an unscored writing sample. Let's dissect them. The first, and for many, the most terrifying section is analytical reasoning, better known as logic games. This is the part of the test that feels completely alien. You'll be given a scenario, a set of variables, and a list of bizarre rules. Something like 7 environmental delegates, A, B, C, D, F, and G, are being seated at a rectangular table. Delegate A must sit next to Delegate C. Delegate B cannot sit at either end of the table. If Delegate F sits in the 3rd chair, then Delegate G must sit in the 6th chair. Your job is to make deductions from these rules to answer a series of questions. It sounds like a pure nightmare, but here's the secret the test prep companies don't want you to think is so simple. Logic games are the most learnable section of the entire exam. It's not about innate genius, it's about pattern recognition. There are only a few fundamental types of games. Once you learn how to diagram them, how to create a visual map of the rules, they transform from impossible riddles into solvable puzzles. Mastering this section is about process. It's about taking a chaotic jumble of information and imposing a system of order upon it. Sound familiar? It's exactly what you'll do as a lawyer when you're handed 1,000 pages of discovery for a complex toxic tort case. You'll have to find the patterns, connect the dots, and build a logical framework. Logic games are your training ground for that. Next up, we have logical reasoning. This is the heart and soul of the LSAT, making up 2 of the scored sections. Each question presents you with a short argument, a little snippet of text, and then asks you to analyze it. You might be asked to find the author's assumption, identify a flaw in their reasoning, strengthen their conclusion, or weaken their argument. This is the core skill of a lawyer. This is the daily grind. When a corporation argues that its new factory will have minimal environmental impact, your job as an environmental lawyer is to dissect that statement. What are their unstated assumptions? Are they using flawed data? Is their conclusion supported by their evidence? Logical reasoning trains your brain to automatically spot these weaknesses. It hones your ability to think critically, to never take a statement at face value, and to understand the precise architecture of an argument. Every question is a mini courtroom battle. You are the attorney, and your job is to either defend or dismantle the argument on the page. To succeed here, you need to become obsessed with the specific literal meaning of words. In law, the difference between some and most, or can and must, can be the difference between winning and losing $1 billion case. This section forces you to cultivate that level of precision. Finally, there's reading comprehension. Don't be fooled by the familiar name. This is not the reading comprehension from high school. You won't be reading pleasant short stories. You'll be given 4 dense, complex passages on topics ranging from legal theory and scientific discoveries to art history and philosophy. And you'll have to read them and answer detailed questions, all under a strict time limit. The goal here isn't just to understand what the passage says. It's to understand how it's constructed. What is the author's main point? What is their tone? How do they use evidence to support their claims? What is the function of the third paragraph in relation to the first? This is a test of mental stamina and focus. As an environmental lawyer, you won't be reading for pleasure. You'll be poring over dense scientific reports on hydrology, deciphering convoluted federal regulations from the EPA, and analyzing 100-page judicial opinions. You need the ability to absorb complex, often dry information quickly and accurately, extracting the crucial details while not getting bogged down in the noise. That is the skill that reading comprehension is built to test. So, knowing the sections is one thing. Building a strategy to attack them is another. Your journey begins with a single painful step: taking a diagnostic test. Take a full-time practice LSAT under realistic conditions. No distractions, no extra breaks. The score will probably be terrible. That's okay. Its purpose is not to make you feel good. Its purpose is to give you a baseline. It shows you the mountain you have to climb. From there, it's a marathon, not a sprint. You should plan for at least 3 to 6 months of consistent study. We're talking 10 to 20 hours a week. This isn't something you can cram for. You are literally rewiring your brain to think in a new way, and that takes time and repetition. Your arsenal of resources is vast. There are multi-thousand-dollar in-person prep courses, live online classes, private tutors, and an entire library of self-study books and online platforms with video explanations and practice drills. There is no single best method. The right choice depends on your budget, your learning style, and your level of self-discipline. But whatever you choose, the core of your preparation will be the same. Practice, review, repeat. You will live and breathe official LSAT prep tests. These are the real, previously administered exams. You must use them. Working with anything else is like training for a boxing match by hitting a pillow. You need to face the real thing. But here is the most critical piece of advice for your study. The value is not in doing the questions. It is in reviewing your mistakes. For every question you get wrong, you need to spend at least twice as much time understanding why you got it wrong. What was the flaw in your thinking? Did you misunderstand the question? Did you fall for a trap answer? Did you misread a rule? You need to keep a wrong answer journal, where you log every mistake and explain the correct reasoning in your own words. This is the slow, arduous, and deeply uncomfortable process of getting better. It's about confronting your intellectual weaknesses head-on, day after day, until they become strengths. The LSAT is scored on a scale from 120 to 180. The average score is around 152. To get into a top 50 law school, you're generally looking at scores in the high 160s. For the elite, the top 14 schools, you need to be pushing into the 170s. Every single point matters. A jump from a 165 to a 168 can dramatically change your admissions outcomes and scholarship offers. This number will become your obsession, but don't let it define you. Remember that the LSAT is not a measure of your intelligence or your worth. It is a measure of how well you can perform a specific set of tasks on a given day. It's a game, and like any game, it has rules, patterns, and strategies that can be learned. The process of studying for it does more than just prepare you for a test. It begins the transformation that law school will complete. It will teach you a new level of mental discipline. It will forge resilience. It will force you to think with a clarity and precision you didn't know you possessed. By conquering this test, you're not just earning a score. You're proving to yourself and to every law school in the country that you have the raw intellectual horsepower and the sheer grit required to become a lawyer. You're showing them you're ready for the real fight. Because once you've slayed the LSAT, you've earned your ticket to the arena. But getting in is only half the battle. Now, you have to craft an application that tells a story so compelling they can't possibly say no. Your application is not a collection of documents. It's a mosaic. Each piece, your personal statement, your resume, your letters of recommendation, is a carefully chosen tile. Separately, they're just facts and figures. But when you put them together, they create a single stunning image of who you are and the environmental champion you are destined to become. This is your origin story, and you are the one holding the pen. Let's start with the heart of it all, the personal statement. This is, without a doubt, the most misunderstood part of the entire application. It is not a resume in paragraph form. It is not a list of your greatest hits. And it is absolutely not the place to write. Ever since I was a child, I've wanted to save the planet. The admissions officer who reads that will sigh, take a sip of their lukewarm coffee, and move your file to the maybe pile, which is basically the no pile with a prettier name. Your personal statement has one job and one job only: to answer the question why. Why law? And for you, the more critical question, why environmental law? The answer can't be a logical deduction. It has to be a story. It has to be the moment the abstract concept of environmentalism became a concrete, burning fire in your gut. Think about it. Was there a moment? A specific, tangible event? Maybe you grew up near a river that changed color depending on what the factory upstream was dumping that day. Don't just tell them the river was polluted. Describe the sickly, chemical sheen on the water's surface. Describe the warning signs posted on the bank where you used to fish. Make them feel the loss of that natural space as if it were their own childhood memory. Or perhaps it was a moment of intellectual awakening. Maybe you were in a college geology class, and the professor explained the feedback loops of climate change, and suddenly the future didn't feel like a distant concept but an imminent mathematical certainty. Don't just say you learned about climate change. Describe the feeling in that lecture hall, the chilling silence as the weight of the data settled over the room. That was the moment you realized that policy and regulation weren't boring. They were the only tools big enough to fix a problem that big. This is the show, don't tell principle. And it is the golden rule of the personal statement. Don't tell them you're passionate. Show them the 12-hour days you spent volunteering for a conservation group, pulling invasive species until your hands were raw. Don't tell them you're a dedicated researcher. Tell them about the frustrating 6-month-long process of analyzing soil samples for your senior thesis, and the singular thrill of finally finding the data that proved your hypothesis. Your story needs a beginning, a middle, and an end. The beginning is the spark, the event that set you on this path. The middle is what you did about it, the classes you took, the internships you pursued, the research you conducted. This shows you don't just have an idea, you have initiative. And the end is the future. It connects your past experiences to your future ambition, explaining why a law degree is the necessary, indispensable next step. And not just any law degree, a law degree from their specific institution. Now let's talk about your supporting cast, your letters of recommendation. A lukewarm, generic letter of recommendation is the silent killer of an otherwise great application. Jane was a good student and received an A in my class. That's a death sentence. What you need is a detailed, enthusiastic, almost personal endorsement from someone who can speak with authority about your skills. Choosing your recommenders is a strategic mission. You need to curate them. Your first choice should be a professor who knows you not just as a name on a roster but as a mind. This is likely from a smaller, upper-level seminar where you were an active participant. This is the professor who saw you grapple with complex ideas, who graded your 25-page research paper, and who can attest to your analytical rigor and writing prowess. Ideally, this is a professor in a related field: environmental science, policy, economics, or philosophy. Your second recommender could be another professor, or even better, a supervisor from a relevant job or internship. Did you intern for the EPA? The Sierra Club? A local land trust? The person who managed you saw your work ethic, your professionalism, and your passion in a real-world setting. They can speak to the skills that don't show up on a transcript, your ability to work in a team, to meet deadlines, to take initiative. Here's the pro tip. You don't just ask for a letter. You prepare your recommenders for success. Schedule a meeting with them. Give them a packet that includes your resume, your personal statement draft, and a list of the schools you're applying to. Most importantly, give them a brag sheet. A bulleted list reminding them of the specific things you did in their class or on the job. Remind them of the topic of your final paper, the insightful question you asked in class that sparked a debate, or the project you led at your internship. You are making their job easier, and in doing so, you are guaranteeing a more specific, more powerful letter. Next up is your resume. A law school resume is not a standard one-page corporate resume. It's an academic and professional history. It can be 2 pages if your experience warrants it. Every single line item should be a brushstroke in the portrait of a future environmental lawyer. Your entire environmental journey should be laid bare. The environmental science club you presided over, the field research you conducted in the Amazon, the part-time job you took at a recycling center, the articles you wrote for the college newspaper about campus sustainability initiatives. Use powerful action-oriented language. You didn't help with a project. You co-authored a peer-reviewed study on the effects of agricultural runoff on local frog populations. You didn't work at a nonprofit. You drafted informational pamphlets and organized community outreach events that increased local recycling participation by 15%. Quantify your achievements whenever possible. Numbers are concrete. They stick in the reader's mind. Finally, a word on the optional essays and addenda. First, optional is a trick word. If a school offers you more space to tell them how great you are, you take it. This is often the "Why our school?" essay. This is your chance to close the deal. This requires deep, specific research. Do not just say, "I am impressed by your world-renowned environmental law program." Name names. I have been following Professor Elena Rodriguez's work on water rights in the arid West, and her recent article in the Stanford Environmental Law Journal directly relates to my senior thesis. I hope to learn from her and potentially contribute to her research at the school's water law clinic. That sentence proves you've done your homework. It proves you aren't just applying to them. You are choosing them for a specific, well-researched reason. And the addendum? This is for explaining blemishes, not making excuses. Did you have one terrible semester because of a serious family emergency? A short, factual, non-emotional paragraph is all you need. State what happened, acknowledge its impact on your grades, and point to the rest of your transcript as evidence of your true academic ability. If you have a minor character and fitness issue like a citation for underage drinking in college, disclose it. Be honest, be concise, and show you learned from it. The bar examiners will find out eventually. And a lie of omission on your law school application is a ticking time bomb that can destroy your career before it even begins. Put it all together: the compelling narrative of your personal statement, the powerful testimony of your recommenders, the detailed blueprint of your resume, and the laser-focused precision of your supplemental essays. When the admissions committee picks up your file, they won't just see a collection of documents. They will see a person with a clear past, a determined present, and an unstoppable future. They will see someone who isn't just qualified but necessary. They will see the next great environmental lawyer. And that is a story they will want to be a part of. And when they do become a part of your story, when that acceptance letter arrives, it's not an ending. It's the beginning of the real trial. The story you told got you through the door. Now, you have to build the hero of that story. You have to forge the lawyer you promised them you would become. Welcome to law school. Forget everything you think you know about studying. Forget your comfortable undergraduate habits of memorization and regurgitation. Law school is a different beast entirely. And your first year, what's known as the 1L year, is designed to break you down and rebuild you from the ground up. It's designed to teach you not what to think but how to think. And for a future environmental lawyer, this foundation is everything. You will walk into your first torts class and you will feel like an imposter. The professor will call on a student, and for the next 20 minutes will pepper them with questions using something called the Socratic method. It's a relentless intellectual interrogation designed to expose the weaknesses in an argument, to force you to defend a position you didn't even know you had. You'll be reading hundreds of pages a week from casebooks filled with dense, archaic legal opinions from the 1800s. And you will wonder, what does a case about 2 guys arguing over a fox hunt have to do with saving the planet? The answer is everything. That 1L curriculum, the set of classes every single law student in America takes, is the bedrock upon which your entire career will be built. They aren't random hurdles. They are the fundamental tools of justice. Let's look at them through the lens of an environmental advocate. Your torts class? This isn't just about slip and falls. This is the law of harm. It's the legal theory behind suing a corporation for dumping toxic waste that seeps into a town's drinking water, causing a cancer cluster. This is where you learn about nuisance, the legal concept that allows a community to stop a factory from spewing foul-smelling, lung-damaging smoke over their homes. Torts is the law that says, "You harmed us, and you will be held accountable." It is the original environmental law. Then there's property law. You might think it's about who owns what, but it's so much more. It is the law of the land itself. You'll study water rights, determining who gets to use the water from a river, a farmer, a city, or the fish who need it to survive. You'll learn about mineral rights, the very issue at the heart of battles over fracking and mountaintop removal mining. You will dissect the law of easements, the legal tool that allows a conservation group to permanently protect a forest from development. Property law is where the conflict between exploitation and preservation is fought, deed by deed, acre by acre. Contracts, the driest sounding subject, but it's the language of commitment. As an environmental lawyer, you will live and breathe contracts. You'll be drafting complex settlement agreements with polluters, forcing them to fund a multi-million-dollar cleanup. You'll be negotiating land acquisition deals for a nature conservancy, ensuring every clause protects the ecosystem in perpetuity. A single poorly worded sentence in a contract can be the loophole a company uses to bulldoze an endangered species habitat. Mastering contracts is mastering the art of the binding promise. And then the big one, constitutional law. This is the blueprint for the entire country's legal system. This is where you debate the very authority of the federal government to regulate the environment at all. You'll argue about the Commerce Clause, the small section of the Constitution that gives Congress the power to pass sweeping legislation like the Clean Air Act. You'll wrestle with the Takings Clause, where the government's ability to protect a wetland might clash with the developer's property rights. Con law is an abstract theory. It's the high-stakes battle that determines whether the EPA even has the right to exist. Finally, there's civil procedure, the rule book. It sounds boring, but it's the most important class you'll take. It's the how. How do you file a lawsuit? Who has the right to sue? A concept called standing that has stopped countless environmental lawsuits in their tracks. Which court do you sue in? How do you force a corporation to turn over the internal documents that prove they knew they were polluting? Without civil procedure, all your knowledge of torts and property law is just trivia. Civil procedure is the key that unlocks the courthouse door. Surviving your first year is a rite of passage. You'll emerge tougher, sharper, and thinking in a completely new way. And that's when the real fun begins. In your second and third years, you get to choose your path. You get to specialize. You will finally enroll in your first official environmental law class. This is the survey course, the map of the entire battlefield. You'll learn the alphabet soup of federal statutes that form the backbone of modern environmental protection. The CAA, the CWA, RCRA, CERCLA, NEPA, the ESA. The Clean Air Act, the Clean Water Act, the law governing hazardous waste, the Superfund law for cleaning up the nation's most toxic sites, the National Environmental Policy Act that requires the government to think before it acts, and the Endangered Species Act, one of the most powerful conservation laws on Earth. From there you dive deeper. You'll take administrative law, and this is the secret weapon. Most environmental law isn't made by Congress. It's made by agencies like the EPA through regulations. Administrative law is the law of government itself. It teaches you how to challenge a rule that weakens pollution standards, or how to defend a good rule from an industry lawsuit. It is the playbook for influencing the real-world decisions that affect our air and water every single day. You'll take natural resources law, focusing on the management of public lands, our national parks, forests, and wildlife refuges. You'll study the laws governing mining, timber, and grazing, and the epic legal battles to protect these wild places from overuse. You might take energy law and find yourself on the cutting edge of the climate crisis, studying the regulations for oil and gas extraction, alongside the legal frameworks needed to build a massive offshore wind farm. You could specialize in land use law, learning the local zoning ordinances that determine whether a developer can build a strip mall on top of a sensitive local stream. But law school is not just about what you learn in the classroom, it's about what you do. You must seek out practical experience. You will join your school's environmental law clinic. Think of it like a teaching hospital for lawyers. You'll stop reading about cases and start working on them. Under the supervision of a professor, you'll represent real clients. A low-income community fighting the construction of a landfill in their neighborhood. An activist group suing to protect a threatened turtle. You will write briefs that are filed in actual courts. You will feel the weight and the thrill of real responsibility. You'll compete to get on your school's environmental law journal. This isn't just a line on a resume. This is your chance to enter the academic conversation. You will edit articles from the nation's top scholars and lawyers. You will write your own, diving so deep into a single narrow topic, like the regulation of agricultural runoff in the Chesapeake Bay, that you become a genuine expert. You will contribute to the body of knowledge that judges and policymakers rely on. You'll join the moot court or mock trial team. Here you learn the art of performance. You'll stand in a mock courtroom, your heart pounding, and deliver an oral argument to a panel of practicing lawyers and judges who are grilling you with questions. You'll learn to think on your feet, to be persuasive, to project confidence even when you're terrified. You are no longer just a student, you are an advocate in training. Through these classes, these clinics, these journals, you are assembling your arsenal. Each case you read, each brief you write, each argument you make is another weapon, another piece of armor. You are no longer just the person who wrote a passionate story in an application. You are becoming the protagonist of that story. You are gaining the knowledge to understand the system and the skills to master it. You are learning the rules of the game so you can fight for those who have no voice. The rivers, the forests, the mountains, and the communities that depend on them. You have the academic foundation. You have the first taste of real-world practice. You are almost ready. But there's one final, crucial piece of the puzzle. How do you take all this training and turn it into a job? How do you break into one of the most competitive and important legal fields in the world? The answer is, you don't just get a job. You launch your mission. You take every ounce of knowledge, every late night in the library, every victory in moot court, and you weaponize it for the cause that brought you here in the first place. This is where the rubber meets the road, where your academic journey transforms into your life's work. First, let's talk about the single most powerful tool you have that isn't listed on your transcript: your network. In a field as specialized and interconnected as environmental law, who you know is often the key that unlocks the door. Your network isn't something you build after you graduate, you are building it right now. Your professors are not just lecturers. They are seasoned practitioners, groundbreaking researchers, and former government officials. They are walking, talking nodes in a vast network. Go to their office hours. Don't just ask about the exam. Ask about their career. Ask about that fascinating article they wrote or the landmark case they argued. Show genuine intellectual curiosity. A professor who knows your name, your face, and your passion is 1,000 times more likely to forward you a job opening or recommend you for a fellowship. Then there are your fellow students and the alumni who came before you. Law school is an incubator for future leaders. The person sitting next to you in torts might one day be general counsel at the EPA. The student arguing in the opposite corner of the mock trial might become a partner at a top environmental law firm. Treat your peers with respect and build genuine connections. And use your school's alumni database like it's a treasure map. Find graduates working in the jobs you dream of. Send them a polite, concise email. Don't ask for a job. Ask for 15 minutes of their time for an informational interview. Ask for their story. Ask for their advice. You will be shocked by how many people are willing to help a student from their alma mater who is passionate about the same things they are. Beyond the walls of your school, you need to immerse yourself in the professional community. Join the American Bar Association's section on environment, energy, and resources. Join your state bar's environmental law section. They have student memberships and they are cheap. Go to their events. Yes, you will feel like an imposter. Yes, you will be the youngest person in the room. Do it anyway. Listen to the conversations. Introduce yourself. Collect business cards. Follow up. These are the people who will be hiring you. Let them see your face and hear your passion before they ever see your resume. Now let's talk about that resume. It is no longer a list of your past duties. It is a strategic document that tells one story and one story only. I am committed to a career in environmental law. Every single line item must be viewed through that lens. That research you did for a professor on the Clean Water Act? That's front and center. The law review note you wrote on international climate agreements? That gets a prominent mention. That summer you spent volunteering for a local conservancy, even if it was unpaid? That shows commitment. Use powerful active language. You didn't help with a case. You drafted memoranda on issues of statutory interpretation under CERCLA. You didn't look over documents. You analyzed discovery materials in a toxic tort litigation. Your cover letter is your soul on paper. This is where you connect your story to their mission. A generic cover letter is an instant rejection. You must customize it for every single application. Research the organization. Know their recent cases, their policy initiatives, their guiding philosophy. If you're applying to Earth Justice, talk about their history of impact litigation and mention a specific case that inspired you. If you're applying to a law firm, research the partners in the environmental practice group. Read their articles. Understand the types of clients they represent and the work they do. Your cover letter must answer the silent question in every hiring manager's mind. Why us? Your answer must be specific, well-researched, and drenched in genuine passion. So, where do you send these meticulously crafted applications? The path of an environmental lawyer generally forks into three main roads. First, there's the government, working for the U.S. Environmental Protection Agency, the Department of Justice's Environment and Natural Resources Division, or a state-level Department of Environmental Protection. Here you are the guardian of the law. You could be writing the very regulations that define the future of clean air and water. You could be prosecuting a company for illegally dumping hazardous waste. You are on the front lines, wielding the power of the state to protect the public and the environment. The pay may not match the private sector, but the level of responsibility you get early in your career is unparalleled. The path often runs through highly competitive government honors programs, or by converting a law school internship into a full-time offer. The second path is the nonprofit champion. This is the world of organizations like the Natural Resources Defense Council, the Sierra Club, or countless regional and local advocacy groups. Here you are the voice for the voiceless. You are suing the government to force it to enforce its own laws. You are representing communities fighting against a polluting facility in their backyard. This is mission-driven work in its purest form. It's David versus Goliath every single day. The competition for these jobs is ferocious, and the salaries are often the lowest. Entry is frequently gained through postgraduate fellowships, like those from Equal Justice Works or the Skadden Fellowship Foundation, which you must apply for during your final year of law school. Your application for these roles must scream commitment. A long history of volunteer work and public interest internships is not a bonus. It's a prerequisite. The third path is the private sector advisor. This is working at a law firm. Most of this work involves counseling corporations on how to comply with the complex web of environmental regulations. You help companies get the necessary permits to build a new factory, you advise them on how to clean up contaminated land, and you defend them when they are sued by the government or citizens groups. This work is intellectually challenging, sophisticated, and it is by far the most lucrative path. For many, the key is landing a summer associate position at a firm with a strong environmental practice during your second year of law school, which can lead to a full-time offer. While some may see this as working for the other side, it's crucial work. Without skilled lawyers guiding companies through the rules, compliance would be impossible. Regardless of the path you choose, you must prepare for a long and difficult journey. The job market is tight. You will face rejection. You will have moments of doubt where you question everything. And in those moments, you must remember your why. Why did you start this journey? Was it the image of a burning river? The plight of an endangered species? The fear for the future your own children will inherit? That why is your fuel. It's what will get you through the 50th cover letter you have to write. It's what will shine through in an interview and convince someone to take a chance on you. Because in the end, this is more than a profession. It is a calling. The planet is at a crossroads. We are facing a cascade of crises, a changing climate, a collapse in biodiversity, a crisis of environmental injustice. The law is one of the most powerful tools we have to address these challenges. It is the framework upon which we can build a sustainable and equitable future. The world does not need more people who are passively concerned. It needs warriors. It needs advocates. It needs brilliant, dedicated, and relentless lawyers who are willing to step into the arena and fight. All the study, all the preparation has led you to this moment. You are now equipped with the knowledge and the skills. You have the shield of the law and the sword of your intellect. The fight for the future of our planet is the defining challenge of our time. It is a fight we cannot afford to lose. And it's a fight that needs you. Now go join it.